Okay, so good evening, ladies and gentlemen, and also my dear friend John, and respected Ezekiel, and from the United States. So today, our national base for human rights education and training. So it was very privileged and honored to have the two guests from the United States. One is Professor John Larry, and he is he's a practice lawyer just in the United States, and he is also the professor at the San Diego University in California, and he also has experience just to give the teachings, the professors, and in Russia, for many times, and now he is also just a paper efforts trying to promote just the facilities, the legal educations in China, and try to bring in some of the new knowledge and the new skills, particularly ethical skills in the criminal trial to Chinese students. So actually, he set up summer programs to achieve, just to realize, try to pursue his goals, and this is a kind of just goals trying to help the Chinese students to familiar with the advocacy skills in the United States. So today, and he's coming, and not only just give us how the skills is applied in the United States, but also try to just explain what his program, what his in China, we said, actually, in the United States have a dream, U.S. dreams. Now we also in China have Chinese dreams. Now actually he is also trying to say his dreams. Okay, so not only just to say his dreams, and also how to realize his dreams. So he's not only just his actually profound, just the rich knowledge, but also his own personal experience itself is testable for us to learn, just to learn a lot. Okay, so thank you very much, John. And then actually we also have another very important, just the order to have another Mr. Ezekiel, and he is actually a real just a practice lawyer just in the United States, and he mainly specialized in the criminal trial, and all his cases is in the federal court, so this is a high, not only just at the state court, and he's has practiced for the practice law for quite a long time. He has a very rich experience in the criminal trial as a defending lawyers. So, and today he's also not only trying to give us his own experience to try to say how the right to fair trial leads to the advocacy skills, and how just put it this way, how the advocacy skills will play, what kind of roles the ethical skills will play in substantially to guarantee the right to fair trial for the individual, for the accused in the criminal trial. So we all know, because fair trial is one of the human rights, it is one piece of human rights for the individual persons, in particularly for the accused in the criminal trial. But of course, I think for the criminal trial, not only just so it's only just to protect the rights of the accused, human rights accused, but also we need just in broad sense. So criminal law court is also one of the venue to protect the victim's rights and the rights of general public. So Ezekiel, and he has very experience with that in this field. So today, this even is the program, the presentations. Actually, we have 3 parts where we complete the 3 parts. First, we would just have the privilege to have Mr. Skill try to collaborate the relationship between the right to fair trial and the ethical skills in the criminal trial. And then second part, so we will just try to have the mooting show, try to moot in the for the fictional times in the different stage of the criminal trials, how the lawyers and the prosecutors apply its own skills in the case. And finally, and the job will tell you just his dream and how he realized his dream. Okay, so first we would like to invite Mr. Ezekiel and to give us presentations and to collaborate the relationship between the right to fair trial and the ethics skills in the criminal trial. So let's get we want Mr. Proud to welcome the Mr. Skills with our presentation.
Thank you. Thank you. Good evening. Can everyone hear me? Okay. Hear me in the back? Good, because I don't like microphone too loud. What is a law in a country that cannot be enforced, if not an empty law? In the United States, we have constitutional rights that provide our citizens and everyone with the rights to a fair trial if they are accused of a crime. In our country, everyone is presumed to be innocent. I understand that you have the same in China now. In the United States, we have had several rights in our Constitution. All those rights were created in 1780 something, after the Declaration of Independence, and those rights gave each one of our citizens the right to the presumption of innocence, the right to an attorney when accused of a crime, the right to have a prosecutor prove the crime beyond a reasonable doubt. Not 51%, not 75%, not 80%, higher. We have also had the right of freedom of religion, the right to free speech, the right to own a weapon. We have many rights. Again, these rights were written in the late 1700s. And one of the very important rights that we have in the United States is the right, which will be involved in this case, is the right of every person who has been arrested and charged with a crime to not be forced to incriminate herself. Yet, in the United States of America, it was not until 1965, was that Miranda, 1965? 1965, that the great democracy of the United States enforced the right to not have someone incriminate himself. United States versus Ernesto Miranda. Why is that? Why do we have all these rights, all these theories that we love democracy, we protect people, yet we don't enforce them? So what do they mean? Nothing. It's like your boyfriend, your girlfriend says, I love you, but I don't know if you do or not. That's why in the United States, and that's why we're here, in the United States we have the right to have lawyers advocate for people. And in this presentation tonight, you will see a presentation from us on first, whether someone should be given bail or detained without bail, even though there's a presumption of innocence. You will see motions to have the government not use evidence that was obtained perhaps illegally, and statements, remember the Fifth Amendment, so they should not be allowed because they were obtained illegally. And you will see what a lawyer like myself, as a defense attorney in the United States of America, I have no power. Zero power. I am like one little grain of sand in a big beach. The prosecutor has most of the power. Most of the cases, the prosecutor says to his honor, I want to use this evidence against that person. He's a thief. He robbed $255,000. Put him in jail. The judge will say, yes. What else would you want? Wasn't he? Okay. So what do? I have no power. Maybe the judge will put me in jail. So today we're going to try to demonstrate to you what I can do for that accused over there, because the theory has to become the reality or else it's empty. And through this program, what we hope to do, and Mr. Clear is the one that's driving this, and although I'm the famous lawyer from the United States, you know who is my master? So if I make a bad presentation tonight, it's his fault. Thank you.
Okay, thanks, Mr. Executive. So now we move to the second stage for the powers. So we have the moot, that's the moot. So, would you like just to do the general introduction? Okay.
In this case, Your Honor, the defendant is charged with bank embezzlement and a false official statement to an FBI agent. There was a bank loss and at a bank where the defendant, Wu Xingyang, worked as a part-time employee. He was a student at San Diego State University, and at the computer that they located, which was the source of the loss of $255,000, it was determined that only 3 people had access to that computer. As a result, the FBI, after determining the loss at the bank, commenced an investigation, and they sought a search warrant as to the 3 people that used the computer, including the defendant, Mr. Yang. As a result of that, they obtained from the court an official order of search of the house and the contents of Mr. Yang. At that house, they found a computer. They were not able to evaluate the computer at that time. They took possession of it and took it to their laboratory where they did a search of the disk. And on that, they found a transaction, a wire bank transfer, initiated from that computer to a Bahamas bank outside the jurisdiction of the United States, which sent, interestingly enough, the same amount of money, $255,000, to the bank. At that time, the government moved to interrogate the particular defendant in this case, and the FBI went out to interview him at the school. He was not in custody, and at that point, there was no need for a Miranda warrant. The standard, you have a right to remain silent, anything you can be used against you, that was not required. And he explained to him what was going on. There was some discussion about a lawyer, but not formally a request. And then there was a mention by the FBI agent that the man who was at the bank, our defendant here, was on leave. The bank, after he was indicted, formally charged with these offenses, to put him on leave, but he was still paid. And he said to him, "You're not cooperative with me, you may lose your job." Now, Mr. Yang is technically a student on a visa in the United States, and his status is under 2 holds, the criminal status and the administrative status with immigration. At this point, Mr. Yang told the FBI agent that he obtained the money gambling, and that this is how he got the $255,000. The FBI, as a result of that, went out and checked all the casinos. He claimed it was in Las Vegas, and they keep a record of any transaction for anybody earning over $10,000. It's done for tax purposes. There was no payment. Mr. Yang came up with the story later that he wanted it a private, and then later brought in a witness that said he witnessed him winning the gambling. The witness later admitted that Mr. Yang induced him to do this, and that he had lied when he made the statement that he witnessed the gambling. At that point, this case was brought, and now we are before the court on a bail determination. A warrant has been issued. Mr. Yang has been placed in custody, and now there's a prompt hearing. The first hearing, the judge determined detention, which means no bail is set, no conditions for release. Now we have this hearing with counsel for the defense, raising the issue that he should be released. He has a good record, a good background, but I, the prosecutor, am here to resist that, to ask that he be detained. Thank you, Your Honor.
Thank you.
May I give a little bit?
Yes.
Thank you. The defense side of the opening statement.
Oh, no, just
Just a little bit.
Well, just to try to make the judge give the story. That's students is familiar with
Yes.
the story. Okay. So,
Yes.
wait a minute. So now we'll just okay. So please sit down.
See?
Yeah.
Thank you.
Yeah.
See how it
You
is?
see what I mean about the prosecutor?
Okay. So the next is just the Mr. Clary and gave the Professor Clary gave the general introduction for this the whole story. Yeah.
Right, he starts the.
Yes, okay. So, actually, I will introduce today. So, Curry is act as a prosecutor, and Ezekiel act as a defense lawyer, and Mr. Robert will be act as accused, the young, the students young, and I'm not just lucky to just sit here as a judge. So, and today actually we put on the demonstrations of the 3 criminal trials and hearings, three. So this will complete 3 different stages. Okay, one is a bail hearing. So when the defendant seeks release after arrest. So then second is a suppression hearing. So where the defendant will seek to exclude evidence of unlawful search and involuntary admission. And the third part is a sentencing hearing. So where the convicted defendant is sentenced. So the defendant actually just I do not give the more details for the story because this Clary actually have already just told the story. So now, so we start our first session. Okay?
Yes,
Is that ready?
Yes.
Good. Yes. So on hearing the bail for the bank theft and the false official statements, are the counsel ready?
Yes, Your Honor.
So proceed, defense counsel.
Thank you, Your Honor. Your Honor, as you know, there has already been an order issued with a different lawyer defending this young man that he be denied bail. I'm going to suggest to the court that that ruling be reversed for the following reasons. Before you, you have a very young 24-year-old student at San Diego State University. He is the son of a very good family. His father is a professor, and his mother's a doctor. He has absolutely no prior criminal record. He is in the United States here on a student visa. That visa was taken by the FBI when he was arrested. And I am suggesting to the court that because the Bail Reform Act, the bail law, states very clearly that in all cases such as this, not a drug case or not a case of violence, that bail is presumed to be appropriate and that no excessive bail should be set. The prosecution before told the court that you should not set bail for a 24-year-old student with no prior criminal record from a very good family because he was a flight risk. If he were given bail, he would fly away, although he has no documents to do that. He cannot go to the airport, he cannot buy a plane ticket, he cannot go to Mexico, he cannot go anywhere without documents. And what I'm suggesting, Your Honor, is that because the Bail Reform Act does provide for bail, because in the United States, we do have the presumption of innocence, and because there are alternatives to secure his appearance before the court, that the court modify the detention order and issue an order that provides the following. To alleviate the concern of the government, which is valid, to alleviate the concern that this young man poses a risk of flight, that you order that he be released on bail with a satellite tracker on his ankle. a satellite tracker that has a certain band that goes around the ankle that he cannot simply cut, because if he cuts it, there'll be a signal sent to the supervising pretrial officer. And at that instant, they will know that either it has been cut, and they will immediately go searching for it. Second, that you require that the money that is in the Bahamas, in a bank account, the $255,000, be repatriated and deposited with the clerk of the court, and that the parents post $30,000 additional security to ensure his appearance, and that the parents who are in China sign the bail for him so that the professor and the doctor, very well respected people in the community, are putting on their word that their young man is going to appear in court. And just to the court for bail. Again, I cannot say enough that the Bail Reform Act presumes that someone will have bail with the least restrictive alternative. Thank you.
Thank you. Yes, Your Honor. Very briefly, we start off first with the fact that the real issue in this case is, will he be present for trial? That is the first and foremost interest. That the interest of society must be protected because we have serious offenses before the court. The amount of embezzlement or theft of a bank of this amount is serious, in the range of about 10 to 15 years confinement. In addition to that, we have the lie to an FBI officer. The absence of documents, the turnover of his passport, is not really valid because he can go to the consulate and get another passport. On the issue of the conditional device, we have a situation where he could go to the Mexican border, which is very porous, especially going south, cut it off at the border, be into Mexico on a plane in Tijuana and out of the country. If he is back in China, we have no extradition treaty with China. So there is no way to bring him back to the United States. So in this case, when we have to look at balancing the interest, yes, his freedom, there is the presumption for reasonable bail. In some cases, bail is appropriate, maybe in 30% of the cases. But in a serious case like this, given his status, a guest of this country, you have to weigh the dangers to society against that. I do agree with counsel's suggestion if the court decided on bail. I fully concur with his suggestion that the $255,000 be returned from the offshore bank and deposited with the clerk of this court. But before I agree to that, only if the court would grant bail, I would recommend to the court that detention, in light of the circumstances and in light of the possibility and very strong likelihood that he might not be here for trial, that he be maintained for trial. Further, I would add that under our law, we have a Speedy Trial Act so that he can request an expedited trial on the issue of this matter.
Okay, thank you. Your Honor, may I? Yes, very briefly. On the tracker, the ankle tracker, he cannot go to Mexico to the border, and the border is not porous. They have customs officers in the border in Mexico. So that the minute this young man moves 25 meters from where he's supposed to be, they're going to know that. He's not going to get to the border. But even more important, what compels bail here, and I would like the court to accept the prosecutor's argument that the only issue right now is risk to flight. How does one evaluate that this young man poses a risk that if you give him bail, he's going to flee? First, you have to consider what would motivate him to run, to flee. I submit to the court that we know that he will not. How do we know that? I'll tell you how. The sequence of events, as you know, is the FBI is told that there's some money missing from a bank. They investigate, they find a computer access to the bank. The FBI, with other officers, get a search warrant from a judge. They go to the young man's apartment, where there are two other young men who live there. And then what happens? They get everything they need, including the computer, they seize it, and they take it with them to search it. Because they don't have enough to arrest them yet. Listen to me. They do not have enough to arrest them yet. So they take the computer away to their lab, and then they search the computer. And then they think, okay, now we have probable cause. Let's go arrest him. But first, we interrogate him. What does that show for bail? You might ask, Your Honor. I submit a compelling fact that should compel you to set bail. Because if the risk of flight is the whole issue here, after the FBI left his apartment with the computer, with all these officers that showed up to scare the living lights out of him, he should have fled to China. What more compelling fact do you need that he does not pose a risk of flight? In fact, the opposite. He waited to be arrested. Thank you.
Very briefly, money is money. And in this case, we have $255,000 missing from the bank and $255,000 that he shipped out. Second, we have, when we get the computer, we have the authorization of the court. The computer is reasonably examined, and it reveals that he sent $255,000 to the offshore bank. And so in this case, we have more than probable cause. But we have even more of his guilt, an issue not to be addressed here because we're only speaking of probable cause, in the sense that
Your Honor, I will object with due respect to counsel. This is not a trial. This is a determination whether he has a propensity to flee. I'm stipulating that as a condition of bail, this young man will surrender the $255,000 to deposit it with the court to be secure. The only issue here is risk of flight. This is not a trial.
Okay, it's a response to the risk of the flight.
The major issue on the flight is, and about point I was about to make when I was interrupted by defense counsel, was that the issue is his also veracity. We see that he lined up a false witness to cover him on the gambling issue. So we have, first, the missing money. Second, we have the same amount of money being transferred offshore. Third, he lies to the FBI agent. Fourth, we lies another witness who admitted he lied to cover him on the gambling. He wasn't with him. That I give it in these circumstances, and I'm not here to argue, counsel is correct, the issue of only the question of probable cause and the risk of flight. When if he returns to China, he's home free. I think that the interest of this country in having a serious violation of this matter requires that this court can only detain him.
Yeah, no, Your Honor, I will submit.
Yes, so you will submit. Okay, so before that, can I just ask a few questions about that? So, has the accused just surrendered his passport?
He had a visa. He did not have a passport.
No passport. Yes, and visa. Yes.
They took his visa, his student visa.
It is a visa.
So he has no travel documents.
No travel documents. Okay. So, do you have any question? I just probably had asked just to respond to that because he said the risk of flight, but now you just said his lies to the FBI.
He lied to the FBI, which is the issue in this case.
Yeah.
But more importantly, and this court can consider this issue on the matter of bail,
Okay.
is that he obtained a friend to say he was with him in Las Vegas
Yep.
when he won the gambling.
Yeah.
And he lied about that. So the story about how he got the money was a lie.
Okay.
And so now, when you hear the bail petition, you have to determine his character and honesty for the purposes of determining whether he will appear for trial. And I think in light of that, they've been compromised completely.
Okay.
Yeah,
Yes, please. Yeah.
I believe it was Alice in Wonderland, Your Honor.
Yeah.
You put the cart before the horse. First, we have the hanging, and then we have the trial.
No, the trial.
We have not had a trial.
Yes.
So no one can say that he lied.
Yeah.
He's presumed innocent. You cannot assume on a probable cause standard that he lied to the FBI. We don't know. We have not had all the evidence for a trial. So
Okay,
that's
very nice.
enough to
Okay,
consider.
that's good. Thank you.
Thank you, sir.
Thank you. Okay, so I can position. But generate the detention and it's a bail on the, oh, okay. Probably I think that we just bail on the conditions such as ankle GPS, okay? And also cash bail, so you should pay. I suggest probably just $300,000 US dollars. Okay, it's okay. The point is okay, so this is a trial for the anyway, just for the fair trial. So their activities are very just good experts in this sector. I'm just the layman that's sitting here, just try to maintain this order. So now, probably you can have any questions. For example, probably why in these bail hearings. So what's the main issues? We should know what one see the balance, so what we need balance. And what skills should we need it? So in order to just, okay, to make sure that this, the accused should be bailed out, not just stay in detention, in the custody for the, waiting for the just trial. So you can have the questions, or I think the first counsels, if you can just to give a little bit more just explanations on this bail hearing.
I will refer to, anybody have questions?
Anybody have questions? Did you understand everything that happened?
We'll have questions at the end if you'd like, it makes it easier.
May I ask you a question?
Yes.
Thank you. Let me ask you a question. There was a prior ruling that he should be detained, and he had a different lawyer. Right now, do you think he should be detained without bail or not? How many hands say detained? How many hands say release? Good. You see, this is the role of advocacy. Unfortunately, some lawyers are not very good. I had a great teacher, he's sitting right there. The tragedy of the American system of justice. Everyone hear about the O.J. Simpson trial? O.J. Simpson was guilty according to everyone. He was guilty. Overwhelming evidence. So what saved him? The lawyers. Arguing for him to a jury that was ready to accept his version. So my question to all of you is this: do you see what advocacy does? Anybody? Why, let me ask you a question then. Why should justice depend upon an advocate? Why doesn't the judge do the right thing on his own? Anybody? Nobody wants to speak to it. It's okay. It's okay. In the United States, this is very common. Sometimes a different lawyer will come in and get a completely different result. Why? Simple. Human nature. I'm speaking to this judge and I'm trying to figure out what does he want to hear from me. So I hear something from the prosecutor that we can do, so I'll grab onto the prosecutor, and then he hears something from me that he likes to hear. Let's bring back the $255,000, and then he may agree to bail, and then the judge, persuaded by both of us, or maybe him seeing the light over there, he sees that the parents have $50,000. So $255,000, that's how you come up with $300,000.
Yeah.
Very nice. See, he was the advocate. That's how it works.
Yes. So my concern is that it's I could say when you said okay, he's not possible just to fly back to China because when he had opportunity to fly, he did not fly. But he also just mentions this because there's a force was lie just to even though we have no trial, cannot prove that. But this is also information.
Correct.
So that's why so the possible that put together we use it's better just do not put it into the custody but have the ankle GPS. Ankle GPS we know. Just you can just surveil GPS, so you can just trace him just where he is. And then just put the money because he wants the money. So let him just to be supervised and also try to secure the loss of the bank. And if it's right, anyway, just then do not put it into custody. Let it free is outside the custody. So this is what I am thinking. So this is probably both sides is just try to convince, but give them more information and to make the judge to have the reasonable, just the judgment. So which is try to put, I think the balance to be struck by the judge. So even just prosecutors and also defense counsel. So they also just try to give the more information and all his arguments or his perceived or just his understand the categorization of the facts just to the judges. But they are actually, I think, they are just from his own position. To some extent, it's a little bit just a bias because from his own positions. But of course, he wants to make his arguments, his facts is more persuasive. So that's just judge should be to be heard and to understand and to accept his arguments. So this is probably the most important things for the counsels or defense lawyers or prosecutors the job to do in the courts. But of course, in the different stage for the criminal procedures have different rules and different requirements and different purpose. So you definitely also need to follow the law. So that's why. So the defense counsel to remind me, so this is not trial. I'm just put something now like the trial. So this is actually only just for me, like the lay judge could be the mistakes been made by this lay judges. But for the very experienced judges, normally do not make such this kind of the mistake. But here it says we need to understand why what is a trial, what is not trial. So how to make the justice distinguish to that? What's the standard? So I would like to ask the SQ to please the legal collaboration about what is trial. Why do you think this is a trial? Why is it before that it's not trial? It's just for the bare hearing.
Thank you.
Thank you.
Very good question. What we have today in this demonstration is a pre-trial hearing. The prosecutor is concerned that if bail is granted to this young man, he will flee. The prosecutor has probable cause that he is guilty and he committed the crime. Probable cause is 51%, more likely than not, 51%. However, the prosecutor at the bail hearing has not presented witnesses. I have not had the opportunity on his behalf to confront and cross-examine the government's witnesses. So the defense has not had the opportunity to test the government's case. The difference between a hearing like this and trial is incredibly radical. At trial, the prosecution has to summon all his witnesses, including the FBI agent. And I get an opportunity to hit them, to cut away at everything they have, all their evidence that they have. So at a bail hearing, it is incredibly unfair for a judge to allow a prosecutor to jump ahead and say, trust me, he's guilty. Trust me, he lied. Trust me, he wasn't cooperative. No, we don't have evidence. We have arguments of a prosecutor. So at trial, that's when the flower of the criminal process blooms. Because a trial, both sides, we don't have to present any witnesses at trial. Okay? We don't have any burden. Because the client begins trial with a presumption of innocence. What does that mean? Graphically, simply, starkly. It means that if you have the scales of justice, imagine it in your mind, the scales of justice, okay? The trial begins with one side completely weighed down, and the other one up here. This is the prosecutor side. So the trial is for the prosecutor to present witnesses, present evidence, to begin to push that down. That's probable cause. That's 75%. That's 85%. Not enough. That's 90%. Maybe that's enough. So if the standard for proof of guilt that he lied, remember the charge. This is why it's such a critical proffer. When a lawyer says something to the judge with no evidence, it's called a proffer. I proffer to the court that he's a liar. Okay? What is he charged with? One of the charges is embezzlement. Okay? The other charge is lying to an FBI agent. So if the judge accepts on a very, very light level that he lied, you already have a finding of guilt. That's completely unfair. And that's when we have trials in the United States. And the burden of proof, let me tell you how it works practically. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. You 12 will be the jury. And then the prosecutor, he's a very good prosecutor. I'm afraid of him. He's going to make my client cry in a few minutes. If he presents his case and he begins to bring down the other side of the scale, maybe 11 of you, 11 when you go to deliberate, evaluate, 11 say, I like Mr. Cleary. I think this guy is guilty and I'm embarrassed at him. He's Chinese, I'm Chinese, I want to convict him. And that little lady over there, she said, no, I don't think he's guilty. He's probably guilty. He looks guilty, but I'm not convinced beyond a reasonable doubt. Guess what happens? 1 against 11 wins. He must be acquitted. That's why. So
objection?
federal system. This is a federal case.
You said acquitted.
No, he's a hung jury.
Oh.
I stand corrected, Mr. Clerk. Let me tell you what.
Big mistake.
No, it's not. And he trained me. I'm going to prove him wrong right now. He has to prove that he's guilty, does he not? Yes? If one juror does not believe it, and he begins presumed to be innocent, at the end of the trial, what happened? He failed to prove it. Although in the United States, we have a rule that says that's a hung jury. That's what we call it, like you hang the jury. The jury can't decide, okay? If it's a hung jury, you have to try the case again. It's absolutely right.
Okay, thank you.
Thank you.
So, any other questions? For the audience? Any questions? Yes, please.
We have a trial hearing, so this prosecutor he used a lot of evidence, but you use this young man, his whole family, his students, so this is not how to say evidence, it's just about his characteristics, but he used a lot of evidence. Is that evidence should be used in a trial, and this hearing is just about if he will wrong or not, we can just know that from his characteristics?
Very good question. My answer is, I'll make it simple. Neither the prosecutor nor I presented any evidence. It's argument. But the law presumes, in a case like this, that bail should be set. So we begin with a presumption that he should have bail. The issue is there sufficient guarantee that will make him show up in court? His character, and the prosecutor can argue against me with the character issue. And I open the character issue. He's a young man, his parents are good, he's a good student, so he can attack the character issue. And he can argue that the statements to the FBI agent are false, so he's a liar. So what Mr. Cleary was making, it's actually a very compelling argument. But he didn't win. So don't change your mind. The compelling argument is this, and that's a very good question, young lady, because all I have is reputation. That's illogical, okay? But Mr. Cleary gave a great answer about 5 hours ago. The life of, it's not logical that a character would carry the day, but we have a famous judge in the United States from a long time ago, Oliver Wendell Holmes. And what did he say, Mr. Cleary?
The life of the law is not logic, but experience.
Experience. So that the character of a defendant should be sufficient to assure that he's not going to flee. So, why do I have a bail? Almost nothing. But according to the bail, it's called the Bail Reform Act, and it has a lot of considerations for the judge, okay? And one of the considerations is the character of the defendant. And that's why I offer his character, but you notice one thing? That's King Solomon. He made a perfect decision. He didn't win, I didn't win. And that's what you have, because this is not evidence. This is trying to persuade the court. Very good question.
Yeah, question? No? Okay, so if no questions now, we just, first
Excuse me,
section.
Your Honor, if we were just a procedural question.
Yes.
If we're running a little short in
It's
time.
okay, yes.
I was gonna say, let's skip the suppression and go to the sentencing. That's an idea. That's
Good
okay.
question.
It depends upon the group. If they wanna hear it, it's just, I don't know what your schedule is. We've been here 45 minutes.
No, it's no other problems.
No problem?
Time is okay, yes.
Okay, time is okay. We'll
Yeah.
go through
All three, yes.
all three.
Okay.
No problem?
Yeah, so the next section is the suppression hearing. We have actually choose the, one is for the search, one is for admission, yes, yes. So first, I would like the professor to explain what's a suppression hearing.
Okay. First of all, I have to defer to my worthy counsel.
Yeah.
Because it's his burden, to use the motion to suppress. And therefore, he will explain why he comes forward on using it. The principle about suppression of evidence is, it's the same in your law. There's an illegal search, the results cannot be used. It's involuntary confession, it cannot be used. In this case, it was the search of the house that led to the computer, that led to the overseas bank account. And there's also an argument made by the defense that if the search was impermissible and the information about the bank, which was used by the FBI agent, the argument could be made that the statement would be excluded as the result of the search. It is called the fruit of the poisonous tree. They would have never had the information about the bank unless they had got it through an improper search. The issue as to the statement raises two issues. The first, as to whether or not a person was given a right to have counsel. Did the defendant express counsel? At this suppression hearing, we have not heard from the defendant. At this administrative hearing, we heard from the agent only. And so therefore, the court is bound by the determination of the agent's words. The defendant might have said something other to the police, might disagree with the agent, but did not testify. So the words of the agent, unless in some way compromised, and there's no contradictory evidence, have to be accepted. The second question is to whether or not the mention of the possible loss of the job would make the statement involuntary. And so with that, the defense would go forward, and our position would be that these statements and the results of the search are admissible.
Procedurally, and also this brings up the importance of advocacy for a fair trial, which is tied directly to human rights, the rights of this individual. Procedurally, what happens is many lawyers will get reports from the government after the bail hearing. There will be no trial set. The first hearing that is scheduled is for a motion hearing, so that the lawyer for the defense can think of legal issues that should be litigated. In this case, the defense attorney determined that the search warrant maybe permitted the police to go seize the computer, to go search the apartment. But the search warrant did not allow the government to conduct a second search, penetrate the data in the computer. There's newer cases that say you cannot do that. You have to get another warrant when you find a computer, okay? And what Professor Cleary mentioned is very important. A phrase, fruit of the poisonous tree. That comes from 1930s,
1921.
1921. See how good it is? Wong Sun. Wong Sun is the name of the case. And the theory is very simple. If the government has a poisonous tree tainted with dirty hands when they go in the courtroom, they cannot use the fruit. The fruit is what they found inside the computer. But is that searched legally? So the lawyer will file papers with the court requesting a hearing. So Professor Clear is correct. I would have the burden because I'm the one that said, wait a minute, I know there was a search warrant, and many lawyers, unfortunately, many defense attorneys give up the fight when they see the search warrant. Because it says they have a search warrant, so the search is legal. Many lawyers, unfortunately, stop there and they don't challenge. In this case, there was a good lawyer. So the lawyer filed a motion arguing, number one, there was no probable cause to search inside the computer. There was probable cause to search and search the apartment and seize the computer. Maybe take it with you, but then you need another warrant. You have to go back to the judge and get a warrant for this. Second, the other motion to suppress is that the Fifth Amendment, Ernesto Miranda, your Miranda rights, the Fifth Amendment does not allow the government to interrogate a suspect illegally. And therefore, the interrogation of the FBI agent at the school of these young men was intimidating, and at the same time, although he was not arrested, the agent gave him his constitutional rights. So the lawyer thinks, why would the FBI agent do something he did not have to do legally? He wasn't arresting him, although he had probable cause. So what he did is he said, listen, I want to give you your Miranda rights as though I just arrested you, but I'm not arresting you, okay? So he gives him the Miranda rights. One of the Miranda rights, besides remain silent, is you don't have to talk to me without a lawyer being right here, okay? He's 24 years old. He's from China. He's into finance. He doesn't know the nuances of criminal procedure, okay? So the lawyer thinks, I want to file a motion because this is an involuntary statement. Involuntary statement because although he was not in custody, he did not feel that he could leave. If you're walking down the street today and you're going to your home, okay, and a police officer with a uniform stops you and says, young lady, I want to talk to you. You're not arrested. But do you think you could go away and not talk to the police officer? Same in America. So the argument by the defense to suppress is, wait a minute, he didn't feel free to leave. And when you tell this poor man, you have the right to a lawyer, but you don't need one. If you get a lawyer, that's bad. They'll fire you. That's intimidating, and that's equal, listen to me, equal as if he hit him with his fists. Because you can have a physical hitting or a mental hitting. Either way, it's involuntary. So we move to suppress based on involuntariness. And then later, the judge has the hearing, and then it depends on who has to go first. Sometimes the prosecutor goes first, sometimes the defense goes first.
Okay, thank you. Both of you. So give various explanations about what is suppression theory. So now we move to the second stage. So I have read your motion and response. So FBI agent testifies. Counsel, are you ready to proceed on the suppression search? Yeah.
Would you?
Yes. So first, I would like to the defense or counsel.
Thank you, Diaz. Thank you. Your Honor, we're going to pretend that the FBI agent testified. We're going to pretend that he did not testify. Then I have to tell the judge why he should grant the motion. Your Honor, I'm going to do something very unusual in this case, sir. You heard from one witness, the FBI agent, and I assume that my colleague is going to come back after I sit down and say, well, he didn't testify. As you know, Your Honor, he doesn't have to testify, okay? But out that, let's take the FBI agent's testimony to use her under oath. The FBI agent told you that he found evidence, and I'll address the computer search first. He found evidence on that computer only after he went and looked inside of it. And they didn't search it in the apartment because they didn't have the equipment. So the poor FBI, with all the millions of dollars they get every year from the government, they didn't have the equipment to search a computer at the scene. But I suggest that's not the reason that it wasn't searched at the scene. The agents knew they had to get another warrant because that search within a search. So after they found the data in the computer, then they went and investigated some more. I would suggest to the court that the penetration of that computer is another search as though it was another residence and they needed an independent warrant. And you know that that's what the law from the Supreme Court says about cell phones and about laptops and about computers. So we'd argue that the search of the computer itself was unlawful. They needed another warrant, therefore the search is without a warrant and is not justified. Second, the statements obtained from this young man. I will ask you because the prosecutor is probably going to say this to you. He's going to say, you didn't hear from this defendant. Again, he doesn't have to testify as well. It is the government who has to justify the search. And the FBI agent told you something very interesting about the statements. This is an experienced FBI agent. He goes, after he searches the computer, by the way, he was not arrested when the computer was removed. So the agent goes back, and where does he go? Not to this young man's apartment. He goes into the school where all his friends and colleagues are. And here's this FBI agent, and with a badge. I want to talk to you. Well, the FBI, you saw the FBI agent testify, Your Honor. He didn't say, I told the young man that he didn't have to speak to me. He didn't say that. He said to you, although he wasn't in custody, I went ahead and was very nice. I gave him his Miranda rights. Your Honor, why would an FBI agent, trained, experienced agent, do something he doesn't have to do? If he's not in custody, Miranda is not triggered, as you know. So, but the agent believed that he had to give him his rights. I submit to the court that this agent knew that he had to because this young man was scared, his demeanor was such, and although you didn't hear that from the report or the testimony, you can infer that as a logical inference. So then what happens? You know that an involuntary statement, even after Miranda, if there's some coercion involved, it is totally inadmissible. Totally. So what happens? Here the FBI agent testifies to the court. You saw him? He said, yes, I gave him the right that he sort of made equivocal things. He's 24 years old. He's not a trained lawyer. What did this 24-year-old student in finance, by the way, not law, what did he say? Well, maybe I should have a lawyer. What else is he going to say? That's an invocation of his right. This trained FBI agent instead says, no, you don't want a lawyer. That's worse. What do you call that, Your Honor? When a law enforcement officer that should be professional with a 24-year-old kid, he's supposed to say, okay, you know what, you're right. Let me have some time and you talk to a lawyer. No, he didn't say that. He says, if you don't talk to me, you're going to get fired. I'm sorry, Your Honor. Under any interpretation, that's a coercive atmosphere. Therefore, any statement provided by this young man under those circumstances is not involuntary. Thank you.
Briefly, as to the search, the whole concept of a search, protect the Fourth Amendment, is to ensure that the police are supervised, that there is judicial review of their actions. In this case, the search warrant reads, you can search his house and all the contents therein. The argument made here by counsel would be, why? You found a locked refrigerator in his house. The court has approved the search of the house and all the contents therein. Now do they have to go out and get another search warrant so they can come in and unlock the refrigerator? Nonsense. Because the Fourth Amendment is determined by reasonableness. And therefore, under these circumstances, the protection under the Fourth Amendment was satisfied by a judicial officer giving the permission to the law enforcement officers to search a house and all the contents. And that is sufficient. And the reasonableness of it. And that is the reason why we have the protection. Because when you go into any house today, can you expect the normal contents not to contain a computer? So it's like saying, well, you can't search a computer. Yes, there is law dealing with cell phones in a unique context. But not where a order of the court says, officers, you can go forward. Because the Fourth Amendment is not unreasonable in its application. It takes into consideration what reasonable law enforcement officers would do. Second, and it's to the state. I love counsel dearly. He's a very qualified guy, very experienced, but he twists the facts here. He says, oh, inferences. Now, this is really interesting. We're not raising any question about the failure to come forward and testify in this hearing. That's not before. We're not before a jury. We're before a judge alone, who can be very rational and considerate. Heard only one version. He threatened my client. Whoa, whoa, whoa. This agent never threatened him. He takes and twists the giving of a Miranda warning sought by the United States Constitution, implemented by Miranda in 1966, and flips it. If the agent had not given a Miranda warning, would counsel over there be jumping up and down, shaking his arms and fists? Oh, they violated my Miranda rights! Oh, he'd be going through the ceiling. But because the agent were not required, because the agent could come out, grab him by the scuff of the neck at school, drag him down to the FBI interrogation room, put the lights and the cameras on him, and talk to him there, now that might be a little coercive. Now you got to give the Miranda warning. But out at the school, with his fellow students around, can I have permission to talk to this man? The agent comes in, shows his badge. He's required by law and agent regulations to always identify yourself when you come in. It's being flipped. And then we have, well, he gave a Miranda warning. You have a right to remain silent. Anything you say can and will be used against you in a court of law. If you do not have funds, counsel will be provided for you. He's saying, what? The very thought that, oh, would it help me if I had a lawyer? The Supreme Court of the United States has directed that issue. Out of here. Unless it's clear and unequivocal. I demand a lawyer. Now you get a lawyer. Oh, I think it would be nice to have a lawyer. Wouldn't it be a good idea to have a lawyer? Zap! Out of here. No way. No way. Now we go to the, I love it, involuntary. With this guy hanging by his thumbs in the interrogation room, we see the agent giving a couple of punches. Hoom! Hoom! And the defense counsel tells us, oh, get over this. Oh, the words can hurt my poor cause. Oh, just think of those nasty words driving right through my heart. Oh, how terrible those words were. What were they? Miranda rights? Oh. Because you were indicted, formally charged, grand jury having heard your case, probable cause determined that you have committed these offenses. And the agents come out to talk to you about this charge. And now you say, whoa, the company put me on leave. Did the FBI agent put him on leave from the company unpaid? No. And if you're an employee in a bank and they're making an inquiry concerning losses of this amount, you would think a normal employee should cooperate, not the agent's turf. He said, is it not possible that you might lose your job for failing to cooperate on this issue of what's going on? That is not an involuntary statement. It is a comment on what might be a probable consequence of what could occur. He's not saying, I'm going down to the bank and make sure you lose your job. Totally different. Counsel is trying to bring in through the back door, contrary to what we heard the agent say here. In a nutshell, this was a valid search, it's a good statement, and both motions should be denied.
When I was a young man in law school, Your Honor, I learned a great saying that's been very helpful, and indeed I saw it materialize before you. I was told as a young advocate, when you have the facts, argue the facts. When you have the law, argue the law and the facts. When you have neither, pound the table. That's what he did. Your Honor, with all respect to my learned counsel and teacher, this was not a search of a refrigerator. There is specific case law that applies to a computer and a cell phone. And that is precisely why when you are a very good FBI agent, presumed to know the law, such as showing your badge with this 24-year-old, the FBI agent in this case, Your Honor, you see it, he applied for a search warrant for the homes. What we are supposed to do here now in the 21st century is to put in the contents of computers if some are seized. That's particularity, specificity required by the Fourth Amendment. That was not the case. Second, the agent did not merely read Miranda warnings. Had he done that only, it would have been fine. The agent did a little more. What did he do? He conflated two issues that are completely separate and independent of each other. As intelligent people, you must ask yourself, why did he have to say, oh, you are on leave from your job? You've been arrested. He hasn't been arrested yet. He has not been arrested yet. Precisely the argument, why then did he give his Miranda warnings if he's not arrested? That's a bankrupt argument. We pounds the table. So what happens then after that? An FBI agent does not have to hang someone like in the mid-century Europe when they used to hang people by their thumbs. That's prehistoric almost. No, a psychological coercion is just as powerful, as you know, Your Honor, as a physical one. There is no need whatsoever for the agent to go beyond the man. You have the right to have a lawyer present. And maybe because he gives a vague request, maybe I should have a lawyer. There is a case right on point from the U.S. Supreme Court that says that is questionable invocation of his rights. So I ask you, Honor, under a reasonable standard, what is an FBI agent supposed to do under the law when you get a questionable invocation of Miranda rights? Make sure that this 24-year-old kid is communicating properly. A young man, why do you say maybe? Engage in a little discussion. Fair. And if he says, well, I'm scared, maybe I should have a lawyer present. And then say, well, let me tell you that you have the right to do that. No, the FBI agent did not do that. The minute the young man made a general invocation, maybe I should have a lawyer, what did the agent come back with, Your Honor? Oh, you're going to lose your job. So I ask you, sir, what was the motive of the FBI agent to say to this young man, if you don't talk to me, you're going to lose your job? What do you call that? What was the need for that? It was to overcome his will to persuade him to talk. No, he wasn't hung up on thumbs. That's not what we're arguing. The professional FBI agent did not have to threaten a 24-year-old kid with losing his job. But in fact, he needed to do that. That's called coercion, psychological coercion.
Okay. So I hope just looks like that's the arguments. So now I would like to deny the suppression of the search of the computers. Okay. So thank you. So this is the first sections of the second part. Okay, and we still have the. So do you have any questions? So you can see the differences of this time the arguments or the skills used in these sections is different from that used just in the previous sections. So, and in particularly, so the template. So this is a very this is learned from this law students learn from the law schools. So if you have the facts, argue the facts, you have the law, argue the law. You have neither have the nothing, you have nothing. So why he punished, he give it back. So this is have a very strong implication. Sometimes you should use in the court arguments. Okay, so this is not only just the arguments, legal argument for the law, but actually, so this is really the technical skills just be used in the court defense in the arguments. So this is I think it's very impressive. So and then we move to the second suppression the theory on the admission. Okay, so the FBI agent and defendant have now testified. Are you ready to proceed on the suppression of the statement? Okay, so first I would like to ask the counsel, the defense counsel.
I thought we did that, Your Honor.
We did
We addressed the suppression.
You just have to rule on it, that's all.
Yes, we just have to rule.
We just have the rules. Okay, yes, sorry. So, denied.
That's realistic.
Yes.
It's real.
Yes, denied. Okay, so and then any questions? Which challenge? So let's hold the table. Yes, please.
A very short comment. Because I noticed that attorney, when you make your statements, you use some of their storytelling skills. I think when I was a law school student, my experiences in law school, it's like a persuasion strategy, for my understanding, using their advocacy process. So my question is whether it's a common skills or strategy used in U.S. court. Because according to my limited experiences in China, we don't find lawyers do this to persuade the judges or the jurors. So my question is about, is common or it's not? Yes.
Very common. And let me answer your question with a question, if I may.
Yes.
What definition would you give of the word advocacy?
It's more like a debate or a logic reasoning.
You said logical reasoning. Logical reasoning, I submit, needs no advocacy. How much is 2 plus 2? Why would you need to convince someone that 2 plus 2 is 4? So what does advocacy mean?
It's kind of as to at least according to your performance, I think it's like comprehensive strategy used to draw people's attention and persuade people.
Correct. And it is not only allowed in the United States, indeed, it's encouraged. Otherwise, you would not have advocates, you would have robots. Because then there would be no need. So it is extremely invited. And Professor Cleary recommends a movie that everyone should watch. It's an old movie from the United States. It's called The Verdict. And why is that a great recommendation? Because I do the same to highly experienced lawyers when we have workshops. We take one weekend, we go somewhere with no phones, no computers, no email, and we ask ourselves, how can we be better? Okay? And the reason why The Verdict is very good, it answers your question. When you see the closing argument, that was a civil case, but the advocacy is the same. In a closing argument, a drama-inclined advocate like ourselves, the ones that pound the table, okay? And the reason why he pounded the table is because I did it too. You see, we're picking each other's tactics. He's trying to off-balance mine. That's good advocacy, if I may say it. In The Verdict, the closing argument was about 5 minutes. He did not cover all the facts. He did not cover all the evidence. He just got up in front of the jury. You see it. You have to see it. Get it on Netflix. He gets in front of the jury and just speaks philosophical, ethical things for 5 minutes, and then he sits down. That's not a closing argument. Yet, it was extremely powerful because his advocacy, his dramatist, which was very honest, see, he was an alcoholic attorney who had fallen off the profession. So he came back to the profession because a woman needed him. So he stopped drinking. So when he talked to the jury, he talked from the heart. That's the quintessence of advocacy, young man. Because you can move a human being to do what they would not do.
If I can just briefly comment on that. I can fully concur with what he said. And this is the problem I faced in Russia. I was in Russia for 8 years at Moscow State University. And 3 years here in China, so I don't have as much experience here. But there's a big fallacy in the legal business. In the old days, 50, 80 years ago, law was a science. It's not a science. It's an art. It's an art. To answer your question, and he just mentioned it, it's the interpretation of the facts. If you have facts, A plus B plus C equals D, that's easy. No brainer. But when you got two different, like in the statement and the interrogation, two different versions, the defendant's version, real life, the agent's version, you've got to interpret which one is right. Second, always know your audience. We have made this a little more theatrical. Normally, we have a hardcore, tough, seasoned judge here, okay? One who is, no, seriously, who knows the law, wants these things quick, doesn't want to waste a lot of time, doesn't want to hear any emotion, zero, none. And so, he, in a normal trial, is our focus, and the only focus. Okay? Here, we play to you, more like a jury. And so we have to have every audience. When I speak in a jury trial, I have three audiences. First, the fact finders, the jury. The judge gives the law. But he's the one that decides the law that they hear. So I have to be nice to him. I can't make him mad at me, okay? I have to make the jury's happy and I have to make him happy. Okay. Then, to protect myself, because I have a tattoo. It's in Russian. Родиться проиграть. If any of you know Russian. Born to lose. Okay? And that we lose as defense lawyers. I'm a prosecutor, I'm a winner now. But in real life, I'm a loser. So we will take it up to the appellate court. So my third audience is the court reporter, who's taking down every word. So I have to speak to you, the jury, to the trial judge and not make them angry, but at the same time, I'm setting them up for the appeal. And the last I'll come back with is a great author in the United States. He summarized Socrates. And he had three things that you had to have. First was ethos, logos, and pathos in speaking. Ethos, what are the qualifications of the individual? Now, you might thought it was a little emotional, a little very Chinese, very, very Chinese. That why go into this little personal stuff? But use the personal stuff with juries. But I have argued a court of appeals in a case where I had a case where a trial judge and a man asked for an attorney, but the judge didn't want to give it to him on the day of trial. No attorney. You will represent yourself. There was a brief recess taken. He went over and talked to the prosecutor and said, I'll recommend you don't get more than 2 years if you plead guilty. And then he comes back on the record and he says, I want to plead guilty. And the judge says on the record to the prospective jurors, thank you for coming today, but for your presence here, this matter wouldn't be quickly resolved. The issue was, did the judge deny him a lawyer? So when I go before the learned jurists, there's three of them in the Court of Appeals. Tough. No jury arguments. Nuh-uh. You don't argue a jury up there. I came up and I said to the judge, Your Honors, I made a horrible mistake. I wasted 3 years of my life going to law school. Because all I needed to do was to talk to this trial judge, who in 10 minutes told the poor defendant, here's how you try and represent yourself in a serious criminal case. They reversed the conviction. So I use my personal experience, but each is a different level, and it's a different audience, and you have to adjust to those audiences. Life is art. Law is art.
And also, I think this is also one of the responding to this count, so these implications just say, okay, because this is the routine way for the legal education. If you have nothing, no evidence, no facts, no law, then you count that. Why he counts it? Because there's no, just try to give the implications, imply, say, okay, he has no law, basis, legal basis, or have no facts basis. Why? That's why he answers. So this is also one of, probably it's also can be regarded as a debate in China, something like, so this is responsive for the way, that's why, so when we see, I think this, as you say, it's legal education in the United States. So because the United States legal education is very universal popular, so everyone is almost the same. So this is probably in China, maybe it's not, because different schools, law schools have different theory, different approach. So that's why you cannot say, when I was studying that university, I was teaching that. He said, okay, different. I'm teaching you Tsinghua University, it's a different way. Okay, so, but anyway, so this is a personal experience is also most important. So this is just trying to give people, so what's a common sense, or the common knowledge of the people. So this is I think, so we are not just, okay, so this also I think is very much a very important inspiration for us just to know, so what is ethics, in particular when the both, the council gives a very good, very good speech just on this concept. So now we move to the last section, which is called sentence theory. Sentence theory. Okay, so after jury trial and defendant Young was convicted of false statement to the FBI, the maximum punishment for his offense is 5 years confinement, 5 years confinement, and fines of $250,000 US. The probation officer, in his presentence report, using the sentencing guidelines, recommends the probation. So serve 6 months confinement and pay a fine of the $250,000 US. So I read and consider each of your sentencing memorandum. So now we proceed this trial. So we'll first of all call just the defendants.
Thank you, Your Honor. I would suggest to the court that you follow the probation officer that prepared that report for you. The probation officer did not prepare that report for us. In his report, this very experienced probation officer, sir, recommended 6 months in jail. I believe that is fair and just. This is a 24-year-old graduate student pursuing a career in finance. As a result of this conviction, his entire career may be ruined. We may not have a chance at appeal, although, as you know, we have an obligation to pursue an appeal. But assuming that the conviction is affirmed by the Court of Appeals, this is severe collateral damage and punishment. So I believe that's part of what the probation officer considered. He considered the full picture. You have before you a young man who made a mistake. A young man who may have had sophistication even, I'll give you that, because he studied finance. So he knew what he was doing, no doubt. But he's 24 years old. His judgment is not fully developed. So what would I recommend to the court besides following the probation report? I would recommend to the court that he pay a fine of $255,000. In other words, the money that we suggested to the magistrate would be repatriated. The magistrate did not listen to us. That our client would be more than willing, we already spoke about that. He's going to do everything necessary to repatriate the $250,000 to provide to the court to give back to whoever the court believes are the victims. We believe that's more than sufficient punishment for the first-time offense of a young man that obviously made a judgment mistake of a great magnitude. As a result of that mistake, his parents have already paid for that mistake. They are terribly hurt. They were hoping that he would be better than both parents. One is a professor, one a doctor. Imagine what happened to their lives. So I would ask the court to consider that 6 months, he's been in jail because bail was denied. 6 months is plenty, with a $255,000 repatriation of that money. I do not call that a fine. He's been found guilty, we pursue that money was stolen. So he will voluntarily repatriate it, and that's an equity that the court can consider. Thank you, sir.
Well, thank you.
The government would respect and concur in the defense's recommendation as to the fine of $250,000. We think that that's a very admirable position. We respect the pre-sentence officer's report, which is a very thorough one interpreting the sentencing guidelines, and we recognize that ordinarily it would fall at 6 months confinement. But we think in this case, what we have here, yes, is a person without a prior criminal record, yes, from a good family, yes, a good student and appreciated by his professors, but also a smart individual, and therefore a responsible individual. And since he's already served almost 6 months in confinement, the court would be giving him, in essence, a pass to accept the recommendation of the pre-sentence report. And we think that in the interest of justice, the fact that this, against our system, when a person comes in and lies to an agent and goes out and literally gets a friend involved to come up to further the lie, aggravating the lie, that this court has discretion. We do not ask the maximum of 5 years. That would be unreasonable and disproportionate. We think that the moderate course, so the court can give a reasonable and appropriate sentence, would be 2 years and a fine of $250,000.
Okay, thank you.
So considering all the facts and the situations, so this court will decide 5 years probation and 6 months in prison and $250,000 fine. Okay, so this court will adjourned.
Thank you.
Thank you. So, do you have any questions about just, okay, so for the whole sessions, still talking about, so now this is for probation, because you say, the guy has actually convicted and was put into jail, but now suppose he has probation, that means he probably can just leave them in the custody for a certain time, they will be released before his sentence. So, and the post counsel actually is a very kind. I don't have to not really use kind, but anyway, they consider this guy, the characters of this, not the not accused, not the defendant. So he talk of just considered and his characters and his future, his families, his whole situations, and give suggestions to that. So this is also kind of the different way for the skills of the advocacy. So to try to settle, just to reach agreement on that. This is also part of that. So do you have any? So still just give you the last chance, last opportunity. Any questions on that? So if now I just to give the floor to the Professor Curry and to talk about his dream. So this is the dream, US dream is also Chinese dream combined.
My Chinese students and American students call me Kong Wong Lao Shi. I'm the old guy, okay. And I was a lawyer for 44 years. I went to Russia for 8 years. I got a doctorate in Russian and Spanish. and I taught at Moscow State University in English and on human rights there on the European Court of Human Rights in Russia, which is a part of it. I came back to the United States and I wanted to learn another language, Chinese. So I studied 3 years at Xiamen University, and I'm still working on it. I'm in my 5th year of learning Chinese. I take 5 hours a week of Chinese online, and 1 hour with a teacher at my university, a very brilliant teacher who puts up with my bad Chinese. But whoa, I love studying Chinese, okay? And it's good for the mind, for an old guy. But my dream, and by the way, this exercise was his idea. That what we did today, it was his idea. He convinced me back in December that this was the way to explain the program. So my goal has been to bring foreign students to the United States. I brought American students for 10 years to Moscow. And then for 7 years, I brought Russian students to the United States. This year will be my 4th year bringing American students to China. And I teach a course, Chinese Criminal Justice. And what I teach is, my first name, my Chinese name is Ming Da Tong. Okay, Da Tong. We're more alike than we're different. And what happens is, in our societies, we look at the differences. Well, you look different. Well, no, it's minor. It's not. In essence, we're the same. When you hear the systems, you exclude evidence. Every motion we had here is the same in the Chinese system. It's just a little different and a little quicker. But it's the same system. So my goal was, now I started bringing American students here. This is my 4th summer. So last year I started bringing Chinese students to America, 1 month. I wanted to make it unpianyi, okay, very cheap, because I wanted to get as many students as possible. And so the tuition is nian fei, okay, it's free. Now how do we get it to be free? You might say, because everybody says, it's slick, all the Chinese, it's too good to be true. It can't be true. Well, it's great lawyers like him that participate. We have 14 to 18 American lawyers donate their services. Some of them are the most famous in the country. The top-notch death penalty lawyer speaks to the group. We had the deputy chief legal counsel from Qualcomm. I'm sure you heard of Qualcomm, the big internet company. She is Chinese American, and she speaks to our group. We have 2 of the teachers who are Chinese American. And part of it is, I want to teach you, and this is my joke, I want to teach you how to speak Chinese. Now you all laugh and say, huh? Because why? You focus on the word Chinese in my statement. I focus on how to speak. And so what I'm trying to teach you is how to speak, whether it's Chinese, Russian, Spanish, English. It's the style. And you can see that our style is a little different from maybe other people. It's a courtroom, formal presentation. It is advocacy because it's adversarial. We come at one another. You notice in the sentencing hearing, he very skillfully co-opted me by agreeing I wanted the money, and he agreed to it. He stole my thunder. So I had to say, I agree with you on that, and the judge was impressed, so he didn't follow my 2 years and he gave him 6 months, so he got the sentence that he wanted. Very slick, okay? But the point was, it's a style. And Chinese Americans we talk too much. Chinese talk too little. Your culture teaches, watch somebody, listen to somebody, think about what they're thinking right now. Get the feeling. What feeling? I feel a little nervous, embarrassed. This guy is leaning down and watching me. That's how you think. That's your culture. And so what you have to do to become a good, that's an excellent trait. I wish more Americans had that ability to focus in on people like you do. But now you got to learn the other part, how to express yourself. He is extremely expressive. I don't know
he's had overseas training or not, but he's very relaxed. Quite a bit different than the rest of you. So I don't, it's different. You will be better than him if you take our 1 month course. Okay? You know, and I'm not saying this, and it's my goal. No money in it for, I lose money. I lose money on the program. But that isn't the issue. I want you, no ideology, no politics. You come up and you make your own determination. The Russians have a term I love, razvedka. I haven't learned the proper Chinese pronunciation. Reconnaissance, recon. Military unit goes out and checks the enemy's territory. It's called razvedka. In Chinese, I pronounce it wrong, but there's one meaning criminal investigation, the other means reconnaissance, and I think it's Chongcha? Juncha? Huh? Gencha, not the criminal investigation, the reconnaissance, the military. Huh? Gencha. The Gencha. Do a Gencha of America. No, seriously, and I don't laugh. How many of you been outside of China? Okay. And so the point is, go. When I first started traveling in the 60s, what country did I love the most? Russia. In our country, the evil empire. I said, oh, I love it. It turns me on. I want to see how different they are. When I got over there, they were just like me. Now, I want to give you that opportunity. And so if you ask me, and he's absolutely correct, my dream, the Confucius Institute has done a documentary on it. Ming Da Tong in the summer programs. And so if you want to find out who I really am, take a look at the documentary. You can find it. And it tells you a little bit of my goal, which is to get you over there to see it. The course, we were very sophisticated because we're all sophisticated. Sophisticated judge, sophisticated defense counsel posing as the prosecutor. We know the business. You're not there to learn it. You learn the fundamentals. Exactly what the professor said here. Professor Liu is absolutely correct. It's to learn a style of communication, formal and persuasive. And you can do it. Each one of you can do it, but you have to reach out. We don't push the law. You go through a drill of acting out the role through 13 cases. We gave you 3 phases here. You don't have to do it the same way. We're expecting the lower level because your English isn't up there. But you go through it, and you have to act it out. It's not sitting and listening. Tonight you were very passive. This is very Chinese. Oh, we like to listen. No, don't. Bushiwan, you shuo. Okay? And no. You got to talk. And part of it is that you get to see my country, and you get to see an opportunity. It becomes a chance to then spring out further to see what else you might want to do. We cover 2 cities. San Diego's most of our activities. We do all sorts of things. We go out and visit a maximum and medium security. Last year, the first thing they did, maximum security jail. Then a minimum security jail. Some of the Chinese students thought it was like a hotel. And then we have police ride-alongs, visit to the police station, several court visits, and we also have shooting. 4 of the female students, none of the male, 4 of the females went parachuting from 4,000 meters. Now that's not part of the course, okay? They did that on their own. But the point is, when you're there, it's an opportunity to improve your English and to understand what it might be. I really got a wonderful, I didn't even ask for evaluations, and the students wrote up their own evaluations. Best thing I ever went through, never found something like this in the university. You made me think and act on my own. You taught me to speak. We had one of our teachers had all of the students shout, and some of the women students couldn't even shout. They couldn't scream. They were too restrained to do so. But part of it is we give it a chance for you to expand. The notice we had in the 1 month from going from very limited English up to very advanced. The problem is not difficult. It's a little complex to read, but this is the worst it gets. It gets only easier from here on. And the whole idea, as you can see here, is the interaction between the two. And the whole idea is speak up. We have a rule in our business. If in doubt, shout it out. And what it means is, most of us feel intimidated when we're around others if we have a view that might differ from the others. And to try to express it, first, be respectful. Second, be courteous. Third, don't be loud. And if you can do it, it's amazing how you can start to learn interaction. And we have a student hotel where we stay. If you want to contact the other students, you got to speak English to them because they're from all over the world. In the place, we go to a law school over there, which is only 300 meters from the place. We go to Las Vegas for 3 days. Some of you got the little brochure. You can see the courthouse where we were with the students from last year. The federal judge, the courthouse is named after him, and he's still alive. And he loves having foreign students. He had my Russian students for 7 years. Now he's had Chinese students for 1 year, and we'll hope to have you again next year. And with that, I would say thank you for coming. And if you had any questions for me about the program, I have my email address. I have also an alternative email address, which some of you may have, some of you may not. It's my China address, real easy to remember. It's Cleary, my last name, John, China, and then at yahoo.com, because Google does not work here. So if you write to my Google account, it won't work. Thank you again so much. Here, that's a look.
This is really just Clarice just is dream. So I think it's a good opportunity because it do not cost too much. You spend generally now I think totally is $2,500 just you should pay for your just travel expense and your living expense. There are no tuition fees. So you have a 1 month experience in the United States. You meet with the very experienced lawyers, just as Zukios and Flurry, and also you visit the federal courts and some of the different places in the United States. But of course, it's up to you. So that's for us, so for me. So I think this is really worth of going and to experience to have the summer programs. So this is depends on you, but you have only to get the big flyers. But of course, we have you can get it on the law school website because I put this information on the law school website, and you also have links. You also have application forms. So and also you can go. We have the Einstein, yes. So we have the Einstein. So this is one of the public public domain, something like the WeChat. Or you can also go to the FDU, Human Rights. So this is one of the for us human rights basis. So you can also get it. So all these informations. And if you determine to go, you can direct it to write to the Clary, and he is also he's Chinese fund, so he also has a WeChat.
Many need my WeChat.
Yeah, the WeChat. Yes, you can just do that. So if you want just to have more information, just of course you can just to ask the Clary and to let him provide just the more information to you. So this is just for us, just this opportunity, provide opportunity to you. So as a professor here, I think this is worth a while going. So that's why if you want us to taste some flavors of the U.S. just the most advocacy, so this is a good program. So this is what I would say. Finally, I just before I end this, I would also like to extend my sincere thanks to the Clary and to Mr. Muskill and for their excellent, just professional, inspiring performance and in this evening, and also with